a politician, and was an outstanding statesman too. He was a great leader, another hero who understand. That's why we remember.
Yeah, good morning to you viewers. I am here with you once again, the fourth Sunday of the month of November. This program comes to you under the auspices of the Forbes Burnham Foundation. And today is an interesting topic under discussion, and I want to say to you that one of the legacies of Lyndon Forbes Sampson at Burnham is the local government system that we have in this country. The local government system introduced under the 1980 Constitution, and critical to local democracy is the question of an electoral list for the various NDCs and municipalities and so on. And today, I am very fortunate to have with me one of the commissioners from GCOM and also chairman of the Forbes Burnham Foundation, Mr. Vincent Alexander, and we'll be discussing the local government system and what is happening based on what is out there in the public domain. And first, before we go on to anything else, I know there have been a lot of talk from different groups and individuals in relation to the list that we currently have. Some people say it's bloated, some say it's not bloated, and a lot of things. Vincent, I want to say welcome to this program, and I want to introduce you to our viewers and to say to you, the first item I'd like us to discuss today is this question of the bloated list.
Thank you very, very much, Clayton. It's a very, very topical question. In fact, only in today's papers somebody has sought to make comments on this question of the list, whether it's bloated or not. I think much is being made of the word bloated. And what one needs to get to is the factual situation. The factual situation is that the Ghana Elections Commission, having had house registration in 2008, took a decision that they would do periodic registration. And why would they do periodic registration? Periodic house-to-house registration. Periodic registration where a new national register of registrants should be created. They scrap the old one. A new one is created based on that registration, and as a consequence, a new voters list is created. This is a decision which was taken by GCOM in 2008. And they said they would do it periodically, meaning every 7 years. Every seven years. Now, this was not a controversial decision. Everybody agreed, government, opposition, everybody agreed that that's the way to go, for us to have a list that's acceptable. This is acceptable. So that's the first point. The question of having an acceptable list through a house-to-house registration was accepted by all. This was not done in 2015, when it should have been done. Was not done in 2015.
Because you agree every 8 years?
Yes, every
Okay.
seven years.
Yeah.
7 years. So the first point I want to make is that anybody who jumps in to say, well, you know, you won the elections in 2011, speaking to the fact that the APNU plus AFC got the majority in 2011, call that they won the election, so to speak, and you didn't complain, there's no basis of accusing anybody of liking the list at that time and disliking it at some other time, because at that time it was 3 years after 2008, and the 7 years had not yet elapsed. The 7 years had not yet elapsed. 2015 again, the list was used, and what one has to bear in mind is that both 2011 and 2015, the government was the People's Progressive Party Civic, so that the APNU, AFC was not in control of anything, both in terms of government and in terms of GCOM. And in terms of GCOM. So it again was not, that registration was not done for 2015. However, before we got to the 2020 elections, the GCOM made the request for the resources to do the registration, and it was granted by Parliament. Nobody in Parliament contested that this should not be done. Nobody in GCOM contested. It was accepted that we'll do a house-to-house registration. And this was to be done in 2019 in preparation for upcoming elections.
You made a request made by GCOM was requiring for the resources, which means that the resources were made available.
The funds were made available under the budget of 2019. And GCOM virtually embarked on the process in 2019. Of course, nobody was protesting or contesting at that time. And the process started. However, no confidence came along. And after no confidence came along, then there was protestation that this process shouldn't go on. They should go straight to elections. Forget everything else. No contest, no confidence, go straight to elections. And so for the first time, doing the house-to-house became an issue. The issue then was not about whether the house-to-house was the right thing to do or not. It was about no confidence, and you shouldn't do anything, so you can get to the elections as quickly as possible.
But even if you have no confidence, an electoral list being accepted is critical.
Yes, it is critical, but they had just no confidence. There was a contestation, and what became critical was that the matter ended up in court, and the judge then ruled, in fact, that we could do a house-to-house, but that we could not, having done the house-to-house, create a new register of registrants or a new voters list. That all we could do is use the house-to-house to add names to the register of registrants, and that after the house-to-house, as a normal part of the process, we could do claims and objections, and those that would allow for dead persons to be removed from the list. So we got to the point where there was this issue that we cannot create a new register. Hence, the issue arose. Why is it we were creating a new register? We were creating a new register because we knew we wanted to go to ground zero periodically to ensure that the list reflected the actual resident present population. And though I use the word resident, it allowed for a Guyanese who was overseas, who was home at the time, to be registered. So we could no longer do that. But the reason why we were doing it still remained, that this list would get out of hand in terms of the number of persons on the list. And so the question that arose after that is, how would you be able to achieve the original objective of having a clean list, so to speak, now that you can no longer do it by way of a new house-to-house
registration?
How do you get to that clean list? And so that became the issue, and that continues today to be the issue. So that when people talk about a bloated list, all of us accepted that from time to time we would go to ground zero and get a completely new register of registrants, a completely new voters list, but that became problematic after the judge ruled. It is on that basis that the question arose, what do we do now? Because we know that we'd agreed we should be refreshing this list, so to speak. And various persons have purported various ways in which the matter could be dealt with. However, there are those who have now stepped in to say, well, the judge has ruled, and in fact, you can't take off people's names off the list, and we have one mechanism that we have, and that is to take the dead names off of the list, and anything else, there's nothing else we could do. And that therefore, since these people who are overseas, whose names cannot now be taken off because we don't have a new registration where they did not come to be registered, we can't say it's a bloated list because they have a right to be there. These people have a right to be there, although they're overseas, and if they're there and the numbers look big, as is the case, because we have a population of somewhere in the vicinity of 750,000, and our list has got as much as 660-something thousand. Bearing in mind, the list only carries those persons over the age of 18. Our school register suggests that we have over 200,000 children, so that in fact, a list of 600 and something thousand really shows that only 400 and something to 500,000 should be on that list, because 200,000 are school children in the population. So we have a bloated list, so to speak. We have a list with names in excess of the persons who are available to vote. And this has become an argument.
All right.
The fact of the matter is that in this argument, it has now been accepted, although they're still saying the list is not bloated, that we do not have any mechanism in place to remove Guyanese overseas who would have died. There's no mechanism in place to remove Guyanese overseas who would have died. It means that any Guyanese between 2008 to present who was registered, and thousands were, and has since died overseas, remains on the
list.
voters list. So whether you call it bloated or otherwise, whatever you call it, the fact is nobody can contest that there are thousands of Guyanese overseas who have died. So I'm just narrowing it down to those who have died are on the list. One only has to look at death announcement in this country, and you can see how many Guyanese on a daily basis die overseas, and their names are on the list. So nobody can contest, no matter what they say, can contest the fact that we have a list with thousands of dead Guyanese who are overseas, and for whom we have no mechanism to take them off of the list.
You mentioned about corrective measures. Some persons have come up with different ideas as to how this can be corrected in spite of what the court had said.
I'll get to that.
Okay.
I'll get to that. So, what some people say, so if what? There's no problem that you have all these names in the list, because we have a perfect system at elections to ensure that there is no fraudulent voting. So there's now this big argument that the system is perfect. We have all the mechanisms, we got scrutineers and everything, observers from overseas. And therefore, even though you have these extra names on the list, there's no way in which anybody can use those names to falsely vote. So there is where we need to have some clarity. What they're saying is theoretical.
Yeah, I agree.
What they're saying is theoretical. Let us deal with reality. What is the reality? The reality is that in the recount 2020, the APNU AFC challenged the names of persons who were recorded as having voted. Now, in the election process, the presiding officer has a pink slip and strikes off the name of each person who votes. She does that. He or she does that. And so during the recount, those slips were available. And the APNU AFC challenged the names of persons which were struck off, saying, hey, the name strike off as somebody who voted, but the person dead or the person overseas. Coming out of that, they supplied names to GCOM. The APNU AFC supplied names to GCOM. GCOM then sent those names for verification. So we ain't talking here guesswork. We're talking about things that occurred.
Facts.
And so, for example, on the May the 22nd, Justice Khadat Singh wrote to the Commissioner of Police. And the letter, which I have here, official letter from GCOM to the Commissioner of Police saying, the APNU AFC is alleging that persons whose names and dates of birth appear on the list attached had migrated and could not have exercised their franchise on March the 2nd. So the APNU saying these people gone away, they couldn't have exercised their franchise. In this regard, I shall be grateful if you will be so kind as to cause the Immigration Department to verify whether these persons were out of the country on March the 2nd. The respective polling divisions and stations where these persons allegedly voted are also identified on the list. The Commissioner would wish this matter to be urgently addressed. So Khadat Singh, writing to the Commissioner of Police
In May.
in May 22nd, 2020, asking for verification, and she would have attached the list that APNU AFC would have supplied. So there's no question about whether GCOM asked immigration people to do a verification. On the 26th of June, under the signature of the Commissioner of Police, from the Office of the Commissioner of Police, a response is sent to Justice Khadat Singh. It says, Dear Madam, I refer to your letter dated May 31st. And forwarded herewith report from the Deputy Chief Officer for Information. So here is the Commissioner of Police responding to a letter sent. And what he does is to attach a list. And on that list he has last name, first name, middle name, date of birth, date of departure. Did not arrive, return on or before 2nd of March. And so he has indicated in this list whether or not people were out of the country based on the list supplied by the APNU. And what do we find is a result of the work that they did? We find that of this list has 211 persons. Sorry, 300 and it has 302 persons. 302 persons. 302 persons. And what we find is that of the 302 persons, 211 were verified as not being in the country. 99 verified as being in the country.
Being
in the country. So they went through the records and they said, look, y'all sent this information, but the information which you sent, 211 correct. They weren't here. 99 were here. And therefore, the 211 persons who were not here are ticked off as having voted means that there was some infraction because those persons were not here to vote.
okay.
So that this question of people saying the system is perfect is theoretical because you have information by the people who are authorized to do certain things in this country to show that a verification was done of an allegation, and that based on that verification, 211 persons on this list, this is only one list, were actually out of the country but were voted for based on their names being struck off on the
On the
pink list.
pink slip.
And that is only one instance. There's another one here. There's another one here. And this one here, there would have been 172 persons who were not in, and
country.
35 who were in. So they verified 172. So what we have is irrefutable. Nobody has contested this evidence. There are people running around saying, well, some people said in social media they were in the country. This list here verified that, yes, 35 were in the country. This list here verified that 99 were in the country. But they also verified 172 was not.
And the other one,
And the other one verified that 211 were not. So that we have irrefutable evidence that nobody has been able to refute that there are people who are not in the country who cast votes.
on
And
March
this
2nd.
here, I can now do a conjecture.
Mhm.
Let us assume that you can't clean the list of the living. But what about the dead? What about the dead? And we know that thousands have died overseas. And we have a situation where we're seeing that hundreds, this is not all the information, this is just a sample,
Part.
hundreds of those persons who are supposed to be overseas, we don't know whether they're dead or alive, were in fact voted for. And so the question still arises, how do we deal with this problem? The CJ say you can't take the people name off the list. You can take the people name off, yes, but we don't have a mechanism to take off the dead who are overseas. So they remain on the list. And you're finding that the people from overseas vote. So what do you do? It is in that circumstance that as the problem continues to be interrogated, there's those of us who have said, let us use a system at the place of poll where fingerprint identification is used to determine whether the person who turns up is the actual person whose name is listed.
Listed, okay.
Right? And that's a very simple system, as far as I'm concerned. There are all sorts of questions about whether the system could work. Well, the system has worked in many places. I have had the privilege and the opportunity to visit other countries as an election observer, and I've seen the system at work. It is very simple. When people are registered, their fingerprints are captured when they're registered.
Mhm.
You simply now have a system where there is a machine at the place of poll where those fingerprints are downloaded. And you come, you put your fingerprint, you put your fingers against the machine, and the machine would correspond your fingerprints with what's in the machine and tell you whether you the person who you purport to be. Simple as that. Simple as that. So that there is this possibility of using a biometric system. But there are those who are opposing the use of this system in GCOM and outside of GCOM. Opposing the use of this system. So that one can only conclude that those who are opposing the use of that system have an interest in those names being manipulated at election time. And so we have a big problem that we're going towards local government election and we're going to go towards a national election sooner than later. And we have not, as a nation, accepted that the problem needs to be resolved. Although previously, when we could have done house-to-house registration and cleaned the list completely, we all accepted it. But after the CJ's ruling, there are those now who don't want even this. We're not talking about everybody now. We're talking simply about possibly a mechanism to ensure that we know that there are hundreds who have died overseas, that nobody can manipulate their situation to come and cast a vote. And there are those who are objecting to that and contending that the list is not bloated. The word voted, you can take it left, right, or center. The issue is not the word. The issue is the fact that there is evidence in 2020 that people who were not authorized to vote voted on behalf of people who were not
here.
present. It's evident. And therefore there is a problem. And the problem has to be solved. If the problem is not solved, then GCOM is not producing an election that is free, fair, and compliant, as is required of GCOM by the Constitution. In the face of this, GCOM refused to do a review of its systems. GCOM refused to do a review of its system. And GCOM so far has not embraced the question of biometrics. In fact, a decision in this matter should be made Tuesday coming, after over 2.5 months. Eventually the matter was discussed on last Tuesday and the decision should be made. But the PPP appointed commissioners have made it clear that they're not supporting this matter of biometrics. The chairperson said she will rule, and I would like to see how she's going to rule on this matter, because it's been clearly suggested that if they're doing a reform of the registration of the representation of the People's Act,
Right.
in that act, there's a provision which provides for how the actual voting is conducted. It talks about going, presenting your ID card. If you don't have an ID card, filling out an affidavit of identity before you go and you cast your vote. And all that we are saying is that if there's need for legislative change, that is where the change could occur. You simply insert fingerprint identification in that process that's already provided for in the representation of the People's Act. And therefore one would expect that if the government has an interest in free, fair, and compliant elections, that in the proposals for reform, they themselves would either make that or would accept the proposition. What does the AG say? He said that's something new, you got to think about it, all sorts of dilly and dallying as we move towards an election, and no attempt to embrace a system which has been embraced all over the world. So don't tell me about if it could work. It's worked all over the world. We've seen how it could work. We've seen it work in Venezuela. We've seen it work in Bolivia. We've seen it work in Peru. There's something similar to it working in Jamaica. So we know that this thing
Could work.
But yet, there are all sorts of arguments about it going to interfere with people's right to vote. How could it interfere with your right to vote if a fingerprint is is unique to the individual and can only determine that it's the right individual who's turned up to vote. Mark you, when we were discussing the budget this year in GCOM, we sought to put into the budget a provision to buy the equipment that would allow for the fingerprints to be taken electronically when there is registration, so that you could reduce any error that could occur with manual fingerprints. Fingerprints be taken electronically, and they refuse to have that in the budget. So there is clear resistance to anything to do with fingerprints being used as a mechanism to ensure that only those who are entitled to vote turn up.
Mr. Alexander, in view of all that you have said and the evidence which, as far as can be deduced, is very clear, it seems to me as though this question of providing an opportunity for free, fair, credible, and transparent elections seem to be is being kind of resisted by only the PPP. And
It's totally resisted.
in this circumstance, local government election date has been announced. Therefore, the preparation for local government election, so this whole question of list and the resistance from them and a mechanism to address this question that has been raised by not just individual organizations, other parties have raised this question. This preparation issue for local government election. I would like your comments on.
Well,
the
it
preparation.
is on that basis that at least two commissioners, myself and Commissioner Trotman, have clearly said that we do not approve of the holding of the elections in the present circumstances. And we gave our reasons. We said, look, if you have GCOP that refuses to review its systems, then what in fact it has refused to do is to put itself in a position to correct any faults or flaws in its system that can hamper the conduct of a free, fair, and compliant election. So we said, look, that's a problem. We can't support an election when you refuse to do a review under all sorts of pretexts, which are false pretexts, because the review has nothing to do with the law which says that if election is disputed, it must go to court. The review is about your systems. And if there are flaws in your systems, it's not about who's culpable or who's wrongdoing.
Administrative functions.
It's about your systems. And if you refuse to review your system, then what you're doing is embracing all the flaws that have been manifest, because there must be some flaw in your system
That
for
cause.
people to be able to come and to vote, although they're not entitled to vote. So there are flaws in the system, and there may be other flaws. So that's one reason why we said we're not supporting the whole of elections. Second reason why we said so was that something strange is happening. And that is that GCOM is preparing for elections. And parallel to GCOM's preparation for elections, you have the government seeking to bring about changes in the law. And according to the Attorney General, these changes will be completed before the elections. But some of these changes would require certain actions from GCOM even now, but the changes are not yet. And so you will have a situation where the laws are changing and GCOM is preparing under the old law for the elections. And therefore you really don't have a preparation representative of what would be the law at the point in time when the elections are being held.
Well, so how could they sanction for an election if
Right.
you don't have that?
And so you have a problem here again, that you're going to run into problems like we have done, because let's take, for example, the parallelism and what's happening. We have a situation where these elections are local government elections. And in a local government election, the law is very clear, as it is, the law is very clear in the Local Authorities Elections Amendment Act 2015. It says, the Commissioner of Registration, on the direction of the Elections Commission, shall cause the electoral registrar to compile a preliminary list of voters for local authority area by extracting from the National Register of Registrants the names and other particulars recorded therein of persons whose addresses are within the area. Now let's note that
Whose
it says,
addresses are within the area?
compile the preliminary list of voters for the local authority area,
Yeah, that's right.
by extracting from the National Register of Registrants the names and other particulars recorded therein of persons whose addresses are within the area. So this is what the law requires. We, GCOM, extracted the preliminary list not based on the local authority areas. It extracted the preliminary list based on the normal divisions that are used
In a national
for
election.
national elections.
And regional election.
That's what was done. Now, what's the problem with that? The problem with that is this, that when you have the preliminary list, you then have claims and objections. And those claims and objections allows for an objection to be made of a person who does not reside in the local authority area to have his or her name taken off of the list for the local authority area. It also provides for a person who has moved out from the local authority area to go and make a claim to be included in the area where he or she is now living. So the way in which we have gone about preparing for these elections has not provided for the public to know that, look, I can object to this person because this person does not belong to this local area. The preliminary list, the way it was prepared, only provided for you to go and object to someone who has died, but not to object to someone who is outside of the local area, but listed in the local area, when the law is very clear that for local government elections, the person must be resident in the local area, and it specifies what residency means. It has a list of things, whether the person is eat at the house, sleep at the house, normally. So that, for example, if somebody has left the local area for occupational purposes to go and do mining
in the interior, right?
Then that person is not removed because the person is considered as still resident.
Okay.
But if the person has moved out, you know, from his mother's house and now has his own house somewhere else, but visits the mother from time to time, that person is no longer
considered removed.
But we have not provided for that mechanism. And that has a number of implications. Because as we get to the point of nominations, it is necessary for people to know who really resides in the area, because only people who reside in the area should be nominated. So there are two issues here. On one hand, people who are not residing in the area may end up being nominated. On the other hand, people are not sure of where they are.
Where the areas are.
Where they are because you did not do a preliminary list based on the local government areas and constituencies. And so people can't use that list as the basis for preparing for local government elections, because the preparation has to be related to the local government area and the constituencies within those areas, because you can also have somebody removed from the list if he or she may be living in the local area but does not live in a particular constituency in that area, living in another constituency. So that basically the preparation itself has also been flawed. And so on that basis we said, look, one, if you don't review your systems, and two, if you have a flawed preparation, we cannot support the holding of local government elections because we have difficulties.
A person who expresses an interest in running in a local authority area, there's some requirements of the law. You got to get people from within the area to have the signature and agreement for you to contest. And how could a candidate, if you want to put yourself up as a candidate, know out of this list? You can't take the national list to go and do that. You have to get a list that applies to the area.
Okay. So what is happening? An order has just been issued for the extraction of the list for local government based on the local areas and constituencies. That order has now been issued. But the fact of the matter is that order has been issued when we've gone past the time for claims and objections.
Yes.
So although there will now be a list that reflects the local government area and the constituency, that list will have in it names of persons who are not entitled to be there because we did not allow for claims and objections to occur on the preliminary list that would have corrected that situation. So there can be the argument now, yes, this list is a local government area list, but it's flawed. It did not come through the process that would have cleansed it, so to speak, for the purposes of local government elections. So we have a major problem where GCOM is proceeding in a manner that is ineffective and I would say even illegal. in terms of how it has sought to prepare the list for local government elections. People have not been given the opportunity at the level of the preliminary list before we got to the revised list to do the kinds of claims and the kinds of objections which are pertinent to local government elections. So there are going to be people who don't live in the local areas, and you must bear in mind that there's been a lot of movement with the housing drive of the government.
That's right.
A lot of movement of people out of areas into other areas, and they are now either going to come and vote where they don't belong, or they're going to decide that since they're living so far, they're not voting, so they're going to be disenfranchised. So in either circumstance, is a problem. They're not entitled to be enfranchised because they move out, and then they're not going to be able to vote where they live because the claim and or the objection was not
provided for. Vincent, I'm really happy that you have been able to clarify a lot of the issues and concerns that have been expressed by the public out there, not just in Georgetown, all over the country. And then only recently on the 26th of November, I heard a statement from our local government minister talking about the raising of taxes, and he is not approving any littering bylaw. We have submitted from the level of the council a bylaw for the littering and a bylaw, and now he's saying about raising of taxes. He's not prepared to perhaps do that. I would like your comment on this matter, because there's some statements coming from the local government minister that I consider irritating.
Right, before I get to that, let me go back to the issue we were raising just now. How you mentioned the minister's name? Because the minister was also in the public domain talking about constituencies and correcting constituencies and things like that. And there is where, again, I talked about the parallelism. He is now doing work on constituencies when the constituency should have been put in place
A long
at
time.
the time of the preliminary list, so that proper claims and objections could have been done. You can't come and extend constituencies after claims and objections, because it means that you did not provide an opportunity at claims and objections for people to relate to the true constituencies that exist. They were, even if they had done the preliminary list based on constituencies, it would still be problematic because you have now changed the constituencies after.
Yes.
But they didn't do it, period. So there's a big other issue here about redrafting local government areas and constituencies after claims and objections.
After claims and objections, the publishing of a national list, and after the claim and
so
objection.
this whole thing is a mess. The minister is creating all sorts of illegalities in the system in the preparation for local government elections. So that's another element that sees the hand of the minister creating problems, and GCOM not taking a position in these matters, happily going along as if what the minister is doing is right. So it brings me to the second question which you have raised. I had, on a previous occasion, I think even on this program, made the point that the minister does not have some of the authority that he's spouting that he has. And I want to be specific here in relation to the municipalities. We've seen on the 26th of November the minister saying he will not allow the municipality to raise taxes.
Taxes, yes, he did say that.
Yes. Now, who has this authority? First thing one should note is that in the laws on the question of tax and rates, there is no reference to the minister. What does the law on tax and rates says? Every council shall, for rating areas within its council area, make and levy for each rated period a general rate, which shall be sufficient to meet the expenditure estimated to be incurred by the council in carrying out its function under this act during the rating period. So what the law here does, it gives the role of determining the rate to the council.
To the council, yeah.
Every council shall, for each rating area within its council area, make and levy for each rating period a general rate. The council shall make and levy, which shall be sufficient to meet the expenditure estimated to be incurred by the council and in carrying out its functions under this act during the rating period. So it points clearly here, the minister not being the one to determine
To make that
rates.
determination.
Now, those rates would normally be found in the estimates as well, because it's revenue. The rates tell you what the revenue
Then
will be.
revenue.
So it may have been argued that, look, all right, you can't determine
Increase,
this.
yeah.
He can't interfere with the rates per se. But previously in the law, it read, a town council or district council shall not later than the 15th day of November in every year cause to be prepared and shall submit to the minister for his approval estimates of income and expenditure of the council for the next financial year. So one would assume that under this law, if you made a rate and you sent it in your estimates, then he could refuse to approve.
Yes.
And so in that way he may have a recourse.
Yeah.
But we have here the Municipal and District Council's Amendment Act of 2013. And what does that act say? Now, the provision I just read is section 157 of the Municipal and District Councils Act, right? Where the minister had the right of approval of
Approve it,
estimates.
yes.
In the amendment, what does it say? Section 157, delete. So section 157 is no longer applicable. It's been
No longer apply to the
it's
municipality.
been removed.
Mm.
So the approval of the minister for the estimates is no longer required. It's
I get
no
it.
longer required. The Municipal and District Council Amendment Act 2013, signed by Donald Ramatar on November the 6th, 2013, says 157, delete. What is 157?
The,
A
the
town
municipality
council
budget has to be approved.
approval of the estimates by the
Because
minister.
in that budget, you would have and maybe possibly an increase in rating purpose and so on, and that.
Right. So
Obviously,
on one
no.
hand, he never had the right
Is
to
a nullity.
determine your rates.
Yes.
On the other hand, the rates
has to
which come in
approve.
the estimates
Has
that
to
he
be
has to
approved.
approve, he no longer has the right to determine those to approve those estimates, and therefore, I don't understand how the minister could be telling the public in this country that he's not going to approve, or the government not going to approve these rates, when the laws that they passed
Has deleted that
has deleted
authority
that
that
provision
was-
and authority of the minister.
Okay, ladies and gentlemen, I know time has been running so fast. Mr. Alexander has provided a wealth of information here for persons who are considering putting up themselves as candidates for the local government election that has been announced. There are a lot of things that are happening, and there are a lot of things that need to be clarified by GCOM, and there are lots of action that GCOM may have to take in relation to this announcement that was made by the government for local government elections. But I want to give you a few minutes, those of you who have been with us on this program, to give you a chance to call in. I have just about 5 minutes remaining before we close this program, but I'm giving you a chance to make your comments on this program so that we can all be informed. Vincent, I know I had calls from Berbice, people from in the Mount Sinai area, La Carber. I had calls from West Coast of Berbice from people who were very concerned about this announcement that has been made by the minister in relation to this action that his ministry is taking to redefine local authority areas. I know you have mentioned it, but and you have also pointed out what kind of confusion this action that is being taken now by the government, what it can cause.
In terms of the local government area per se, that is the boundaries for the local government area, not the constituencies, the minister has the authority to extend and create local government areas. That's his authority.
Yeah.
The problem we have with the way he exercises his authority is that he's exercising his authority at a date after the electoral list would have been exposed for claims and objections, so that, for example, if you take what's happening in Cameroon, where they are now brought together two local authorities into one, and as a consequence of that, internal changes will occur. Nobody was able to make a claim or objection in relation to what's happening there. Similarly, you have changes occurring in, for example, in quarantine, 52 to 74. There are now two local authorities. So when we did claims and objections, people were living in one local authority. Now they're living in one of two. So they were not able at that time to say, well, look, I'm in this one, and therefore I want to operate for local government elections out of this one, both in terms of submission of symbols for the elections, because there are two local authorities now.
Yes.
Submission of symbols, which ended at the 21st.
Yes.
But the local authority area was changed at a time when you couldn't go to the list to adjust.
And to determine where you
a lot of confusion
yeah.
that has occurred. That's occurred.
I'm still very hopeful. I'm hopeful. I'm really, really hopeful that corrective measures, I don't know what those measures are, but like you said, I am hoping that GCOM can take some swift action and make some determination on these matters, because it's a concern all over this country.
Well, GCOM can. The problem with GCOM is that there is collusion, that there are commissioners at GCOM who seem to be working with the minister, and whatever he does, they are supporting it. And therefore, in GCOM, you don't have the will to get things done the way they should be done. And then you have somebody like Nandalal writing in the press, Alexander has to take partial responsibility. That's what he wrote the last time, that GCOM could do certain things, and therefore, as a commissioner, I have partial responsibility. But I can't take partial responsibility if my position is clearly known and is voted down.
Yeah, Mr. Alexander, I want to say thank you very much for being on this program today. We have run out of time, and I want to thank our viewers. I want to say thank you for having us in your living rooms, in your bedroom, maybe in your kitchen. We have been listening to this program. What we do on State of the Nation, which is a program under the auspices of the Forbes Burnham Foundation, we try to provide information that can serve you well in your day-to-day life and your interaction. And for this purpose today, local government elections, information that you need to know, things that you need to do, things that are being done. And I trust that we have been able to provide some data which would help you to make a determination and possibly help you to object to these things that are being foisted upon this nation and local authority areas by the government. Any comment you wish to make before we close?
Well, we are faced with a situation where there's a tremendous denial by some, but I think on the other hand there is a lack of consciousness by others, and we need to have both situations corrected. Those who don't know need to know so they can take the requisite action, and those who are in denial need to be brought to answer for their actions.
Okay. With that being said, I want to thank you once again for being with us on this program, The State of the Nation. I've been your host, Clayton Hines.
Little Forbes, Samson Burnham, we know not what